قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS extension 100 or visit yourrights.com.
هل أنت مضطر إلى إشهار إفلاسك؟ لا تأخذ هذه التجربة لوحدك، بل استشر أولا ومجانا مكاتب المحامية جومانا كيروز، وتكلم مع المحامي المختص بقضايا الإفلاس مايكل بنكستين، الذي سيساعدك على التخلص من ديونك وفقا للبند السابع لقانون الإفلاس بسعر $575 فقط. ومن الممكن أيضا أن تحصل على إعفاء من أتعاب المحكمة اعتمادا على عدد أفراد الأسرة ومدخولك الشهري. اتصل الآن بمكاتب المحامية جومانا كيروز 248-557-3645 والاستشارة مجانية. برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. طابت أوقاتكم بالخير مستمعينا، وأهلا بكم في هذه الحلقة الجديدة التي تأتيكم على الهواء مباشرة من برنامج يور رايتس مع المحامية جومانا كيروز. ككل يوم جمعة حلقة مخصصة لقضايا الإفلاس، وبإمكانكم المشاركة في هذا البرنامج وهذه الحلقة على الأرقام 313-769-6666 519-256-123، أيضا عن طريق الواتساب، وبإمكانكم إرسال رسائل نصية وصوتية على الرقم 313-327-7074. مكاتب المحامية جومانا كيروز تستقبل قضاياكم المتعلقة بالإصابات الشخصية من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، قضايا الهجرة والتجنس، قضايا الإفلاس، وقضايا الضمان الاجتماعي وقوانين العائلة. الاستشارات مجانية على الرقم 248-557-3645. حلقات برنامج يور رايت يعاد بثها مرة أخرى على موقع اليوتيوب. كل ما عليكم هو زيارة قناة جومانا كيروز على اليوتيوب والتسجيل فيها والضغط على زر الجرس ليصلكم كل ما هو جديد. تحياتنا لكم ورحب بك جومانا في برنامج يور رايت. أهلا وسهلا.
مساء الخير، يعطيك ألف عافية. مساء الخير لكل المستمعين وهابي فرايدي.
كيفك رامي؟ الحمد لله، الله يخليك. نسأل عنك إن شاء الله بخير.
كتر خير الله. مساء الخير للجميع ومساء الخير لضيفنا لليوم مثل كل نهار جمعة المحامي مايكل بنكستين اللي بيحكينا عن قضايا الإفلاس Bankruptcy law. Good afternoon, Attorney Michael Benkstein. How are you today?
Good afternoon, Joumana. I'm feeling great. How about you?
I am doing very well, thank God, and thank you for asking. Michael, let's begin by asking you if there are any changes in the bankruptcy courts as far as lifting emergency orders for people who are filing bankruptcy or who are in the middle of bankruptcy, needing to, for example, attend in-person meeting of creditors. I know that there's been an emergency order that has been put in place since, I believe, March of 2020 by the chief judge of the bankruptcy court for the Eastern District of Michigan, which is where we are. We hear Biden talk about lifting orders. We hear about the governor talking about lifting orders. What about the bankruptcy court, given that one, it's a federal court?
Thank you. The bankruptcy court, since it has its own emergency orders, it would have to lift its own emergency orders. So whatever the Center for Disease Control is talking about, or whatever the governor is talking about, the bankruptcy court would have to lift its own emergency orders, and they haven't done that yet. Although I'm monitoring the situation at this time, they haven't had any in-person hearings since March of 2020, and that's still the case.
Okay, very good. So far, there is no change. Of course, you are going to let us know if anything changes.
I certainly will. They haven't changed it at this time, but I'm definitely scanning the horizon for any sense that they're going to change that.
Okay, and since we are talking about that, when we were preparing for the show today, it's this issue of whether or not a person who has filed for bankruptcy needs to now go in person, accompany their lawyer in person to downtown Detroit, because a lot of orders are being lifted here and there. We talked last week about the Workmen's Compensation Bureau, I believe, reopening in the middle or in early July, if I remember. So we were talking about that in the context of a question you get often enough from our Middle Eastern clients, especially now that it's the summer, that things have relaxed a bit. A number of our Middle Eastern clients are choosing to travel, typically back home, Iraq, Lebanon, Syria, etc. And the question is, can someone, if the court is now in person or becomes in person, can someone appear on their behalf? So the first thing we want to say is, one, no change as of today. So wherever you are, whether you are in Timbuktu or Baghdad or Beirut, you can appear by Zoom or you can appear by phone, and the bankruptcy trustee is not going to know where you're calling from, nor is he going to care. However, if things change in the future where your physical presence is required, that will change everything. We're not there yet, correct?
That is correct.
Okay, now let's talk about a question we get asked often enough. I cannot appear in person. Can someone go on my behalf and conduct the meeting of creditor on my behalf?
Yes. What we used to do in that scenario pre-pandemic, when people had to physically show up somewhere, there's something called a motion for debtor to testify at their meeting of creditors. That's the hearing that you go to, through power of attorney. So the way that goes is somebody would sign a power of attorney for someone else to be able to do business on their behalf. Of course, make sure that's someone that you trust. And then once they had signed off on that, I would get a copy of the power of attorney, attach that to a motion that I would file with the court. There is a 14-day notice on that. So I like to have people do that, file that motion at least 3 weeks before the hearing to make sure there's more than enough time. And then the judge signs the order. Now that person can appear on your behalf.
But let's make it very clear. Just because you don't want to go, just because you're on vacation, whatever the case may be, that does not mean that you can file a power of attorney. You can sign the power of attorney, giving power to somebody else to appear on your behalf. The bankruptcy trustee is going to say, okay, done deal. We don't want to lead our listeners into the impression that it is that easy. The procedure itself may be easy enough, but it requires additional work on the office and on your part in filing a motion. And you have to wait at least 14 days for the request to be approved. And the bankruptcy trustee may object, may not agree with it. A good example of a power of attorney that in all likelihood will not be disputed by a bankruptcy trustee is someone who is incarcerated. That person cannot appear. They are in jail or in prison. Or someone who has a serious medical condition. They cannot appear. Those are clear. But as you were telling me in preparing for the show, and that is why they want to give a power of attorney for someone to appear on their behalf, chances are it will be disputed or objected to by the bankruptcy trustee, and also it's gonna bring attention to your financial condition, and it might not be so good, because I think that the bankruptcy trustee is gonna say, wow, you can afford to go on vacation to Beirut, but you cannot afford to pay your debt, right?
That's correct. So actually, between you and me and the audience, it's not the worst thing in the world if it takes the bankruptcy court a little while to reinitiate the in-person hearings, because right now you can do it any place in the world.
However, sooner or later, everything comes to an end, and sooner or later, they may ask you to appear in person, and giving a power of attorney to someone because you're on vacation will not cut it.
That's correct. When you file the motion, the court does expect some kind of an explanation as to why. It's someone has a medical situation. You don't really have to get into what the medical situation is, but it's for, medical reasons, or I'm incarcerated. It's difficult to explain just visiting relatives. Now, again, if you've got a relative out there who's infirm, or maybe, God forbid, in the hospital and maybe on death's door or something like that. But the farther you get away from, I physically can't be there because of incarceration or medical reasons, the definition, the explanation has to be a lot more detailed, for sure, the farther you get away from that scenario.
Okay, so I'm going to translate this into Arabic, and then we're going to take a quick break, and we will continue with our weekly show on bankruptcy with attorney Michael Benkstein. So نقطة من النقاط اللي بلشنا، ما في تغيير بمحاكم الإفلاس. قبل ما يصير في الوباء كان كل إنسان بيقدم إفلاسه مضطر ينزل على المحكمة مرة على الأقل، إجمالاً مرة فقط، بس ممكن تكون أكثر من مرة على الأقل، على شيء اسمه Meeting of the Creditors. ابتداء من أذار 2020 التشيف جادج of the Bankruptcy Court للإيسترن Division of Michigan اللي نحن under its authority طلع emergency order بيقول إنه Meeting of Creditors بينعملوا via Zoom أو عبر الهاتف. من أذار سنة الماضي لحد اليوم 4 حزيران 2021 ما في تغيير بهذا الموضوع لحد اليوم and until further notice. meeting of creditors بعدهم عم بيصيروا عبر الهاتف أو via Zoom. So إذا الشخص المعني بالأمر موجود بالعراق أو بسوريا أو بلبنان، هذا الشخص هو via Zoom أو هذا الشخص هو via the phone. So ما إلها تأثير. بده يجي وقت عاجلاً أو آجلاً بده ترجع تنفتح المحاكم ونزل البيتيشنر على المحكمة رح يصير ضروري. هون حكينا بموضوع هل إنسان لنقول عنده محكمة تاريخ معين meeting of creditors، بس هو ما رح يكون موجود نهارها، مش لأسباب urgent أو لأسباب جدية، يمكن لأن عامل فاكيشن رايح يقعد 2 شهر بلبنان، بالجنوب، بالبقاع، بالعراق، باليمن إلى آخره. هل بيقدر يوكل حدا تاني بالنيابة عنه ليحضر الميتينج أوف كريديتور؟ وشغلة تانية ما حكيناها بالإنجليزي بس رح ضيفها هلأ، هل نقدر أصلاً نأجل الميتينج أوف كريديتورز؟ يعني لنقول إنسان قدم وإجا تاريخ الميتينج أوف كريديتورز وقت بدها تفتح المحاكم أو قبل ما سكرت بأذار سنة الماضي وما بيقدر يحضر، هل بيقدر يطلب حدا بالنيابة عنه يعمل الإجراءات اللازمة؟ الأرجح لا، لأنه الإجراءات بتنعمل بس بتنعمل لأسباب جدية جداً. المحكمة والبانكربسي تراستي ما رح يبصموا لأي سبب ليسمحوا لحدا يروح بالنيابة عن حدا تاني. إذا ما كانت الأسباب جدية، رح نعطي أمثال عن أسباب جدية. مثلاً إنسان مريض ومرضه بيمنعه إنه يتنقل وينزل على المحكمة. هيدا الإنسان بيقدر يوكل إنسان تاني بالنيابة عنه يروح على اجتماع the meeting of the creditor. في إجراءات معينة، في power of attorney بدها تتعبى، في طلب بيسموه موشن مكتبنا بده يقدمه، في انتظار 14 نهار من بعد ما نقدم الطلب لحتى نتأكد أنه البانكربسي تراستي ما رح يعارض على هذا الطلب. بعدين القاضي بيطلع الأمر ومن بعدها بيتم البانكربسي تراستي. يعني وبيكون في تاريخ معين لازم نبلش الإجراءات على القليلة 3 أسابيع قبل التاريخ، لأنه لنقدم الطلب ولننتظر 14 يوم بدنا على القليلة 14 يوم، يعني بدنا على القليلة جمعة إضافية. أسباب تانية مثلا بتكون مسموح فيها، عم نعطي extreme examples، مثلا incarceration، يعني الإنسان اللي قدم bankruptcy بالحبس ما بيقدر يجي. هيدول أشياء إذا الإنسان عطى وكالة لحدا آخر لحتى ينزل عنه ويكمل بالبانكربسي فايلينج تبعه، المحكمة رح تسمع. السؤال اللي بيطرح نفسه، الأشخاص اللي بيروحوا فاكيشن اللي بيرجعوا على بلدهم شهر وشهرين ومقدمين بانكربسي، أولاً هل فينا نأجل الموعد؟ وثانياً هل فينا نطلب من المحكمة إنه حدا تاني يحضر بالبداية بالنيابة عنا؟ الجواب هو سلبي، لأنه تأجيل الموعد، وقت اللي سألته للمحامي مايكل بانكستين نحن وعم نحضر للشو بس ما قلناها بالإنجليزي، فينا نطلب جمعة جمعتين يمكن ماكسيموم شهر يتأجل موعد الميتينج اوف ذا كريديتور، بس مش رح يأجلوه شهر وشهرين وثلاثة. هاي نمبر 1. تاني سؤال، طيب أوكي إذا ما رح يأجلوه أو إذا ما أجلوه كفاية إنه نحن رجعنا على البلد، هل فينا نحط حدا بالنيابة عنا نعطيه وكالة بيسموها power of attorney؟ يس، بس هل رح ننجح وقت اللي حنقدم موشن قدام المحكمة؟ الأرجح لا، الأرجح إنه البانكربسي تراستي رح يعارض، نمبر 1. ونمبر 2، رح تتفتح العيون على هذا الإنسان. ليه؟ لأنه هذا الإنسان يدعي إنه هو ما بيقدر يدفع ديونه، مشان هيك مقدم إفلاسه. من جهة تانية نزل على البلد، دفع حق تيكت، بده يعيش، بده يصرف. بتتفتح العيون عليه إنه أنت إنسان من جهة مقدم إفلاسك، ومن جهة تانية معك مصاري كفاية لحتى تنزل وتعمل فاكيشن بلبنان أو بغير بلد. هو سيف ذو حدين كبار. هي بتكون برأيي أنا موشن خاسرة. جانا اتصال أو سؤال تحت الهواء، خلينا نجاوب عليه. الأستاذ علي بيقول إذا تقديم الإفلاس بيأثر على الامبلويمنت تبعك. عندي فكرة عن الموضوع، وإنما رح نسأل الاختصاصي بهذا الموضوع المحامي مايكل بانكستين. Attorney Michael Benkstein, we received a question on WhatsApp, on the radio WhatsApp. Mr. Ali wants to know whether him filing for bankruptcy will affect in any way his employment.
Thank you, Joumana. No government employer may deny employment to or terminate the employment of an individual solely because they filed for bankruptcy. And that's also the case for a private employer. There's a number of professional licenses in which the regulatory agency asks if you've ever filed for bankruptcy. If somebody answers untruthfully, their professional license could later be revoked. It's better to disclose having filed for bankruptcy. The information itself is less damaging than the failure to disclose information.
So let me stop you for a minute before you give other reasons how employment may be affected. If you apply for a job, any job, private job, let's say, even a private employer, and they make you fill out an application, if they ask you in the application whether you've ever filled out, you've ever applied for bankruptcy or been in bankruptcy, they have the right to ask the question. However, if you answer untruthfully and they give you a job and they later find out that you answered any part of your application untruthfully, then they can fire you for good cause. They can fire you and you cannot get unemployment benefits, for example, because you lied on your application. So you're right. It's not so much the filing of the bankruptcy, it's withholding the information in a private setting in applying for a job that may hurt you if you get the job and it's later found out that you have lied. Some jobs are very sensitive. For example, you are joining the bookkeeping department, the department of any office where money is to be handled, cash or checks or otherwise. I think that information is extremely important, and I think even an employer may choose to withhold offering a job based on the outcome of that. And like you did say, some professional employment jobs and some federal jobs, the filing of bankruptcy may take you out of the pool of applicants. Continue, please.
Thank you.
Other way, yeah.
I've represented many professionals such as real estate agents, mortgage brokers, lawyers, doctors, accountants, casino dealers. None of my clients have ever lost their license as a result of filing for bankruptcy. So, and even in it is possible that if someone's going into a sensitive financial kind of job, that's going to be really relevant to the job. Whether or not somebody is good at handling money. I would say for that, if they do ask you that question, that's your opportunity to explain what happened. So if somebody wants to be a bookkeeper somewhere, but they only filed for bankruptcy because they didn't have health insurance and they got catastrophically sick, well, that's a little bit different than financial mismanagement. So the details are really important. And in fact, that's your opportunity to explain what happened if they ask you if you've ever filed for bankruptcy.
Okay. There are other ways I can think of that may have to do, not necessarily adversely on your job, but the employer is going to know. Isn't it true that if somebody files for Chapter 11 repayment plan bankruptcy and they're going to notify the employer that this employee, is on a Chapter 11 repayment plan and instructing the employer to withhold some of the wages from that employer, correct?
That's correct. In a Chapter 13 repayment plan, your employer will likely receive in a Chapter 13 bankruptcy, your employer will likely receive a pay order from the bankruptcy judge directing your payroll to deduct funds from your pay. People are very concerned about that. But to which I've said, who in your office do you know has money come out of their check for child support? And a person will tell me, I don't know. And I said, does anybody have money come out of their check because they owe the IRS? They say, I don't know. These payroll departments are very discreet with that information. It's really not something that you should be hearing around the water cooler. I've never seen there be an adverse impact on someone's employment because their employer is aware that they're in a Chapter 13. And in fact, in a Chapter 13, you're actually paying what you're able to pay to your creditors. In a Chapter 7, your employer doesn't receive notice of the bankruptcy at all unless you owe your employer money and they're one of your creditors.
Okay, so before we talk about that last scenario, if you know that you are in a Chapter 11 and there will be a repayment plan, our advice is tell your employer before they receive an order. Just tell them, give them a heads up and tell them that, I am in Chapter 11 and I think you will be receiving an order to withhold some of my pay. In fact, when we file for Chapter 7 and 11, not only do you have to tell your employer if you will be in a Chapter 13 and they're going to know sooner or later and withhold, yes, I keep saying Chapter 11, withhold, some of your pay. But in addition to that, we always say, even in a Chapter 7, when you file Chapter 7, tell everyone you owe money to that you have filed, including your ex-wife or ex-husband, because whether you tell them or not, once you file for bankruptcy, the court, you have to list, when you file for bankruptcy, you have to list your assets and your debts. You have to list all of your creditors, the ones you're still paying on time and the ones you want to discharge in bankruptcy. The court is going to notify each and every one of your creditor. Let's say you owe spousal support or child support. Guess what? Your ex is going to be notified. So it's part of the bankruptcy procedure. It's part of how things are done by the bankruptcy court. So our advice has been, notify people that you will be, that who are creditors of yours, even if you're paying them on time, especially when they are in a personal relationship with you. Like your ex, for example, that you will be filing or you are filing. And this way they're not in a shock or they don't think that you're trying to do something behind their back, because whether you tell them or not, they're going to know. The last scenario in which to answer Mr. Ali's question, how can filing of bankruptcy affect his employment? You said it. Some employees have borrowed money from their employers. And then therefore, Mr. Ali, if you've borrowed money from your employer or given you advances on your wages, you have to list that employer as a creditor. And guess what? When a lawyer files a petition on your behalf with the court's going to turn around and notify that creditor. So your employer is going to know. So get ahead of it and notify your employer that you are filing. Anything you want to add to that, Attorney Michael Benkstein?
No, that's a great summary, Joumana.
Okay, thank you so much. We received another question on the radio WhatsApp, and it has to do with retirement accounts. And this question is from Mr. Ahmad, who wanted to know if his retirement accounts are protected. And I assume he's asking, are they protected in the event that he files for bankruptcy? And this is when I have heard Attorney Michael Benkstein say, please don't fix the plumbing, and please don't fix it if it's not broke, and please consult with an attorney before you do something, meaning well, but now you're throwing good money after bad. So, Attorney Michael Benkstein.
Yes. So in a Chapter 7 bankruptcy, there's a trustee appointed by the court to administer the case. They have an economic incentive in selling or liquidating assets for the benefit of creditors. But when Congress wrote the bankruptcy code, they wrote in a number of exemptions or protections that you place on your property. And Congress wrote those exemptions in such a way that in the vast majority of cases, it protects everything. Specifically with a 401k, there is no limit on how much money you can protect in a 401k. The bankruptcy trustee can't touch it. So in reference to the statement about don't try to fix it yourself, I've seen situations where a person comes into the office and they say, well, I'm thinking of filing for bankruptcy, but I know I had $50,000 in a 401k and I didn't want anything to happen to that money, so I cashed out the 401k. Well, congratulations, because if you had just left it in the 401k, there's no limit on how much you can protect, but the amount of money you can protect when it's cash on hand or money in bank accounts is far less than that. So leave it where it is. You don't need to cash out your 401k. You don't need to do anything fancy. Leave it where it is. The bankruptcy trustee can't touch it.
Okay, so the short answer, and it's black on white. The short answers, and it's black on white. If it is a 401k and you are filing for bankruptcy, doesn't matter how much you have in it, does not matter how much you owe, you are protected. You have immunity. That money is safe as long as you keep it in the 401k. The minute you take it out, it is available for the trustee to look into and pay your creditors with. So when we say don't tear the plumbing, or when Attorney Michael Benkstein talks about this phrase, don't tear the plumbing, don't start fixing things, and you're not a plumber. You might ruin things. Talk to a plumber, talk to a lawyer, and any good bankruptcy lawyer will tell you, Your money is protected in 401k. Don't touch it, you're fine. If you are otherwise qualified to file for bankruptcy, you can, and nobody can touch that money. But once you take it out, that's it. You've lost your immunity. We got another question from a gentleman, and this is a good topic to talk about. We've talked about it a few times. We've talked about it in great detail once before in a show, and it has to do with owing back taxes to the IRS and or the state. And here is what I remember, Attorney Michael Benkstein. You said it depends on what years, because I believe you can only go back 3 years. You're going to correct me in a minute. And it depends on whether for that year that you are today seeking to wipe the debt, you filed your tax returns on time. So filing your tax returns for 2021 is April 15, 2022. Filing your tax returns on time for a debt you want to discharge in 2019 implies that you clicked on your file returns on April 15, 2020. So this gentleman says, Rami, we need to know exactly what years. Are we talking about 2019? Are we talking 2020? Are we talking about 2018? If you don't mind, Rami.
Sure.
So Mr. Mazen is asking if his tax debt can be discharged in bankruptcy. And he's looking at, I believe, 2 years back. And according to him, he had filed his taxes on time. We're waiting to get additional information for what years. We are today in 2021. Okay. He's talking about the years, the debt for tax year 2018 and the debt for tax year 2019. So for 2018, he would have had to file on time on April 15, 2019. And for 2019, he would have had to file his tax returns on time on April 15, 2020. Can he today file for bankruptcy and wipe the debt for these 2 years? And yes, he filed his tax returns on time for those years.
Not likely, and I'll tell you why. Because in addition to being timely, it has to be for 3 tax years ago or greater. So 3 tax years ago or greater, and the tax returns were timely filed, are generally dischargeable. If they weren't timely filed, or even if they were timely filed, but they were for less than 3 tax years ago, then they typically aren't discharged.
What is the 3 tax years ago would be April 21, April 20, April 19 for the year 2018. So I think 2018 will be 3 tax years ago.
But we're in tax year 2020. So you go 20, 19, 18. So maybe 17. 17 is a good candidate. 18, probably not yet.
I see. So you look at the year you are in and you count 3 years back. So if we are in 2020, anybody who wants to wipe her or his taxes will have to be looking at the year 2017 or earlier, with those tax returns having been filed timely. So Estes Mazen will not be able to wipe his tax debt if he files bankruptcy for 2018.
That's correct. And one thing I want to throw in there is sometimes the IRS will put a tax lien if it's been a long time since they've been paid. If they actually put a tax lien on it, the lien makes it secured, not unsecured, and then the debt probably would not be dischargeable. So that's another excellent reason to solve the problem sooner rather than later if you can. So, but most people, their situation is that they haven't timely filed the returns, or it's too recent to try and discharge.
So 3 conditions must exist for someone to file bankruptcy today and get their previous year's tax debt wiped out. And by the way, when we say tax debt, does that include IRS and state?
Yes, it's any form of income tax debt. So really, it could be federal with the IRS. It could be state through Michigan. It could be the tax authority of some other state, Utah Department of Revenue. And it can even be the city. 24 different cities in Michigan charge city income taxes. So if somebody owes for 2016 City of Detroit and they timely filed the tax return, they could get rid of that as well. But this is income tax. We're not talking about property tax or any other kind of tax, but income tax.
Okay, so we're going to translate this into Arabic very shortly. 3 conditions must exist for someone today who wants to file for bankruptcy to get her or his IRS tax or state tax wiped out. Number 1, given that we are today in 2021, the debt has to be at least 3 years old. So the latest year you can do that for is 2017 or earlier. The problem is, if you have not paid your taxes in 2017, chances are the IRS has already placed a lien on your taxes. That means if there's been a lien, because it's this long, you cannot file bankruptcy today and enjoy discharging your tax debt for 17 or 16 or 15. The third condition is it's only given to those who have filed their tax returns, not paid their taxes, obviously, but filed a timely tax return. A timely tax return is always filed on or before April 15 of the following year, except, I believe, for 2021, I think they extended the IRS filing to October 2021, and it still be timely, correct?
I believe they bumped it out to May 15th for this year, and last year they actually bumped it out to June 15th. Now, of course, if somebody filed an extension, and the extension is granted, then, that may also apply that it was timely filed. But you don't want to just not file the taxes. I've actually had people say, oh, I prepared my taxes for that year, but I never filed it because I saw that I owed. Well, go ahead and file the return anyway, because if you file it timely, that may open up the door to discharging the tax debt in bankruptcy down the road, provided that you filed it timely and it's 3 tax years ago or greater and no tax lien has been put on it. So go ahead and file it for sure.
Okay, thank you very much. So even those who receive an extension on their taxes and file it by the granted extension, that is also called timely filed.
That's correct.
Okay. So سؤال الأستاذ مازن سؤال مهم جدا، مرة حكينا عنه بطريقة كتير مفصلة، حكينا عنه أكتر من مرة. السؤال هو للإنسان اللي بده يقدم إفلاسه اليوم بس بعد عنده ضريبة بده يدفعها من سنوات ماضية يا الIRS يا الولاية يا الاثنين. إذا قدم إفلاسه اليوم، هل هذا الدين بينمحي بتقديم الإفلاس؟ الجواب بيختلف. في 3 شروط مفروض تكون موجودة. أول شيء، الدين بده يكون عمره أكثر من 3 سنوات. يعني نحن اليوم بال2020 الشخص اللي حابب يمحي دين تبعه ما بيقدر يمحي دين سنة الماضي أو 19 أو حتى 18. بده يكون عمره على القليل 3 سنوات. يعني عم نحكي عن دين بعد مش مدفوع لسنة 2017 أو 16 أو قبله. 2، طالما الIRS والولاية ما رهنوا التاكسس تبعه. كقاعدة عامة الIRS ما بتنطر 3 سنين، مش دائما، بس كقاعدة عامة الIRS ما رح تنطر 3 سنين الإنسان مطول ليدفع الضريبة تبعه. ب3 سنين إجمالا وإنما ليس دائما بيكونوا رهنوا له التاكسس تبعه. إذا رهنوهم خلص it's a lien by law، ما في الواحد يعمل شيء بهيدا الموضوع، وذات الشيء الولاية اللي هو عايش فيها. وثالث شرط، أول شرط دين عمره أكثر من 3 سنين طالما الIRS والحكومة مش رهنينه، والأرجح رهنينه لأنه هالقد قديم. وثالث شرط إنه هذا الإنسان يكون مقدم التاكس ريتيرنز تبعه لهذه السنة اللي هلأ بده يمحيها on time. يعني الشخص اللي اليوم بده يمحي دينه إذا قدم إفلاسه لل 2017 بده يكون مقدم الانكم تاكس ريتيرنز تبعه the following year بأبريل 15 2018 وإذا أخذ extension وقبلوا له الاكستنشن يكون مقدمها ضمن الاكستنشن. سو الشخص اللي ديونه أكثر من 3 سنين وما رهنوا له الاي ار اس أو الستيت التاكسس تبعه ومقدم الانكم تاكس ريتيرنز تبعه on time، هذا الإنسان إذا اليوم قدم إفلاسه بيقدر بيرجع على الأقل لسنة 2017 أو قبلها. الأستاذ أسامة بيقول do I need a lawyer to file for bankruptcy and what if I cannot afford a lawyer? Mr. Osama's question is do I need a lawyer? And let's talk about the fact that nobody ever needs a lawyer, but how will you do if you don't hire a lawyer? And how likely are you to do a good job? That's the question. There is nowhere in the laws that say, in the Constitution, that says you must hire a lawyer. The question for everyone always is, depending on the level of difficulty, complication, and what is at stake, am I better off hiring a lawyer or can I successfully do this from beginning to end? So answer this question, Attorney Michael Benkstein. Do I need a lawyer? And then let's move on to those who cannot afford a lawyer.
Thank you. So you have the right to file for bankruptcy by yourself without a lawyer. I advise against that, though. However, bankruptcy is a highly... What's that?
Strongly.
I advise against filing it yourself, even though you have a right to do that. Bankruptcy is a highly specialized area of the law with very specific requirements. I spoke to a woman just this morning who filed for bankruptcy on her own. She figured it out good enough to put the paperwork together. She knew to go to the hearing or over the phone. She did everything right, except she didn't do her second credit counseling. Well, guess what? You can do everything else right, but if you don't do your second credit counseling timely and file a certificate of completion with the court will close the case without issuing a discharge. And the discharge is the part that wipes out the debt. That's just one of 100 examples I can think of just off the top of my head of why you don't want to try to do this on your own, even though you have a right to try and do this on your own.
When her case got dismissed, was it dismissed with prejudice or can she refile again?
You can refile again, or actually you can, if you do it timely enough. If you let it go too long, some judges don't let you do this. But if you relatively soon file a motion to reopen the case, to file that second credit counseling certificate, you can do that, but the court charges you $260 to do that. So that's just one example of how you cost yourself $260 just on that one issue by trying to do that on your own or blowing a deadline.
So what you are saying is that if she does it timely enough, a judge may allow her to reopen the same case that she filed, but for additional fees. But if the case gets dismissed completely, she can refile all over again. But the problem with all of that too is, in the meanwhile, the debt is ticking and ticking and growing too, right?
That's correct. Now, affordability is a different issue. There's definitely some things you can do to mitigate some of the affordability issues.
Can you afford a lawyer? Okay, so what if somebody is indigent? Are there any pro bono legal services that you know out there, lawyers who will represent, forget the fees to the court, we'll talk about that in a minute, representing someone who cannot afford a lawyer, the attorney fee? Do you know if there are any pro bono legal services out there that represent claimants for free in bankruptcy?
Off the top of my head, I don't know of anybody that actually represents you for free, but there is a pro bono program. Pro bono means for free. The bankruptcy court does have also a pro se program. That means you're doing the bankruptcy yourself. they do have somebody, at least pre-pandemic, who had a position over at the bankruptcy court where somebody could show up and have them kind of look the paperwork over. So there's definitely a pro se program through the bankruptcy court. And there may very well be folks who do this pro bono. Off the top of my head, I personally have never, just on one or two occasions, I've done it pro bono, but I typically don't do that.
You've done it pro bono because you wanted to help, but I'm talking about legal services out there. We know there are legal services out there who help people pro bono, representing them in divorces. And they get grants. Quite often they do these pro bono services because they're a nonprofit organization with lawyers working in there, and they get grants from the state. And some of them will only represent divorced women, not only. Some of them will represent battered women where there is domestic violence. They will be your lawyer from beginning to end for free. And they get grants because they need to live. So they get grants from the state to assist them because they're a nonprofit organization. If you're accused of a crime and you go in front of a judge, it's an honor system, and you tell the judge that you cannot afford a lawyer, then a lawyer will be, it's in your constitutional rights, a lawyer will be given, provided to you for free. In bankruptcy, there may or may not be. You just personally do not know, Attorney Michael Benkstein, correct?
Well, it's I know that the court doesn't just provide you with an attorney in bankruptcy. That's a little bit different than like a criminal case. They don't provide you with an attorney if you're indigent. I just kind of, Googled, pro bono bankruptcy services in Michigan, and I did see one come up. That's a legal aid society that may be able to assist people.
Okay. And yes, a simple Google research for anyone listening who does not think she or he can afford a lawyer. Who knows? I mean, there may be enough services out there, or one service that will take you as a client. However, here is what we know. Putting that aside for a minute, we know, just like in family law and just like in immigration, in bankruptcy law, if you are within so much, and I always confuse bankruptcy and immigration, one is 150% of the federal poverty guideline, and let me see if I can pull them out from the notes that you sent me before, and one is 125%, one is 150% of the poverty guideline. If you can tell our listeners that if you cannot afford to file for bankruptcy, you cannot afford a lawyer, chances are you cannot afford to pay the filing fees with the court, which last I checked were $335, correct?
They just recently bumped it up from $335 to $338.
Okay. And you just corrected me. It's within 150% of the federal poverty guidelines. So the numbers I have are from 2020, but let me tell you what the federal poverty guideline, if you are filing for bankruptcy and you are one person, the federal poverty guideline for 2020, so I'm sure they've gone up a little bit or gone down a little bit, I'm sorry, gone up a little bit, excuse me. If you make less than $12,000 and let's say $500 and you are one person, then if you make 150% of that, then the court will not make you pay the filing fee, and it's not automatic. Your lawyer has to ask for it, or you have to ask for it. If there are two of you living in the household and you make about $17,000 a year, so 150% of that, that would be around $25,300. Then, you can get your. And you said it was bumped, I'm so sorry, from 335 to
338. That just happened earlier this year.
Okay. If your household is 3 people, the federal poverty guidelines are you are within the poverty guidelines is if you make less than 21,330. So 150% of that is 31,900. If you are a family of 4, and we're going to stop at 5. If you're a family of 4 and you bring in about $25,800 a year, 150% of that is 38,000. And finally, if you are a family of 5, by way of example, and you make less than $45,000 a year, you will get that $338 waived. 5 minutes. We want to talk about be careful what you post on social media. We talk about this in workman's compensation. We talk about this in car accidents. And with the 4 minutes remaining, I want you to send a message to all of our listeners who will be or are in the process of bankruptcy.
Thank you. You want to be careful what you post on social media. Sometimes people go to great lengths on Instagram and Facebook to appear to have the perfect life. You might be the guest of your friend at the yacht club. You might have attended an open event to the public at a country club, or a relative pays your way and takes you along with them on a vacation to Spain. But when people look at the check-in photos from those places, they have no way of knowing that you didn't pay any funds to participate in those activities. The problem is the bankruptcy court appoints a trustee, and the trustee has wide-ranging powers to investigate what's going on in your financial life. Nothing keeps them from looking you up on social media. And if they start seeing you in Madrid, 2 weeks after you filed for bankruptcy, or a month before, or whatever, the 2 things come to mind. One, maybe your financial situation is not as modest as you stated, and maybe you have the ability to make payments to creditors, or make more payments to those creditors than you're currently making. Or 2, maybe you have assets which you failed to disclose to the trustee. Don't contradict the reality of your current financial situation by recycling a photo that you took in China 5 years ago before you fell into financial distress. Just go easy on the social media, particularly with the big vacation out of the country kind of posts.
And that even applies to people who are going home overseas. I mean, the question also becomes, you can afford to pay a ticket to go to the Middle East and stay for 2 months, but you cannot afford to pay your bills. And like you said, sometimes perception is a reality, in that somebody looks at something and it can be completely made up and it can be completely fake. And they will either think it is real, or if you are the bankruptcy trustee, you will start investigating, you will start digging. And yes, even if you put a picture of going somewhere, your cousin paid for it, the bankruptcy trustee does not know that. It gives the bankruptcy trustee a chance to start digging and see what else comes up. And once they start digging, there is no telling what else they will find. You've said it repeatedly. The bankruptcy trustee has access to tens and tens of databases on you, from looking you up with the bureau and licensing regulation to see what businesses you own when you allege you don't, to looking you up at the Secretary of State, and these are just simple ones that come to mind, to see if you own more than one car when you allege you own one, to looking at you on social media, to going at least 2 years back on your bank statements and scrutinizing how many dinners you are paying for, and how many unnecessary things you're buying when you claim you cannot pay your debt, and a lot of other databases. So you don't want to open yourself to scrutiny. And they don't have a way of knowing anyhow if this picture is old or new, and if somebody else paid for your lifestyle or is paying for your lifestyle or not. Anything you want to add on this? This was a great show, by the way. We should have it repeated. Anything you want to add on this as far as, social media and what you post?
Yes, just a brief comment. Again, you don't want to make it look like you have the ability to go on a trip abroad on your own funds. The problem is, even if you have an explanation for it, if the trustee thinks they see something, they're going to ask you more questions.
Thank you. I'm so sorry. Thank you so very much. Thank you. Have a wonderful weekend, everyone. A weekend, everyone. A weekend, everyone. A weekend, everyone.